Is she the most relaxed potential mother-in-law that has ever lived? Because if she could tolerate 5 years and not get all over the situation, how should she like really relax with you?
This is the plaintiff, Donna Andrews. She says the defendant stored her old beat-up RV on her property and she owes her money. The woman claims she paid one of her employees in cash. The defendant's lying about it, and she wants the $1,022.28 she's owed. These are the defendants, Lynn and Fred Obermiller. They say this whole thing is one big misunderstanding on the plaintiff's part because she's confused. That's right. They paid the storage bill in full. They have a check to prove it. And now they have a $98,000 motorhome they can't use. They're accused of copping out on a camper.
All parties, please raise your right hand.
What you are about to witness is real. The participants are not actors. They are actual litigants with a case pending in civil court. Both parties have agreed to drop their claims and have their cases settled here before Judge Marilyn Millian in our forum, the People's Court.
Be seated. Come to order, please. Litigants have been sworn, Your Honor.
Thank you, Douglas. Okay, American Coachworks.
Yes.
You are suing Fred and Lynn Obermiller for $1,022.28 in storage fees plus interest that you say they owe you for some time now. Tell me what's going on.
The Obermillers own an RV. It's a 2000 Fleetwood Bounder. After we performed work on it, it was left at our facility.
For how long?
5 years.
Why would you let something be left on your facility for 5 years?
Well, we went back and forth with repairs. They had a lot of problems getting it covered with insurance. There was a lot of problems with this vehicle.
Yeah, but 5 years is not like 5 months. 5 months would be astonishing. 5 years
agree.
is just clearly people aren't doing what they're supposed to do. Either you're not fixing it or they're not picking it up because they're getting free storage from you. Because it's not easy to store an RV.
It was fixed and they were getting free storage.
How long was it fixed and they hadn't picked it up?
4 years.
Why would you tolerate that? Why wouldn't you put a lien on it and sell it?
Because it wasn't worth selling.
Well, then why wouldn't you get it towed and trash and
Well,
get it
after
abandoned?
a while, that's what I did. I finally went after them hard enough with the certified letters to say I want it off of my property, which happened.
4 years? Wow, they must have been laughing. 4 whole years. Okay, so then what happened?
They went to take it out in November of 2013. They got
Without paying the storage fees?
Without paying the storage fees.
At that point, were you charging them storage fees or no?
No, not
At that point, you just wanted it off your lot.
I wanted it off my property.
So they come to pick it up.
And they drive away.
Right.
A mile down the road, they break down.
So you let them bring it back?
No, I did not. What happened is they broke down. Mr. Obermiller received 2 tickets. It was not insured nor registered.
Okay.
So because of that, the police department called a tow company because he was not allowed to drive it. When I went to my company the next morning, there was the RV.
Gotta be kidding me.
No.
Like a bad penny. And then what happened?
They asked if they could store it for 3 months at $120 a month. So in February, they were supposed to pick it up. I started contacting them in March. In April, I started sending certified letters.
Who is that right there?
That is Erin Smith. She works with me. She's my witness.
Okay. She related to you?
She's my daughter-in-law.
Daughter-in-law. Stand up a second. I have a question for you. First of all, how old are you?
21.
Oh my gosh, you look so young. You're her daughter-in-law?
Yes.
Are you married?
No.
Well, she did.
Almost.
Okay, that's not, almost doesn't count, okay?
She works for me. She's my administrative assistant.
Okay, is she the most relaxed potential mother-in-law that has ever lived? Because if she could tolerate 5 years and not get all over the situation, how should she like really relax with you?
Yes.
Yeah. Okay, that's good. Go ahead, sit down. What is going on with you folks? Why do you have a car, an RV that's fixed other than the obvious that it's
All right,
free storage
obviously
for you?
it was not fixed, okay?
For
That's
5
part
years?
of
Why
our
did you leave it
problem.
there for 5 years? Why didn't you take it somewhere else to go fix it?
Because we were dealing with insurance issues. We
For
found
5 years?
For 5 years.
Guys,
we were
no one's dealing with insurance issues for 5 years. You're dealing with insurance issues, they don't go your way, then you get a lawyer if you're right.
We did try
Or you pay
that.
for it yourself.
We did try a lawyer.
That still doesn't take 5 years.
It's still not fixed. The original problem.
No, you didn't know that until 5 years later when you picked it up the first time.
Well, no, that was a whole nother problem.
Why did you pick it up?
We were told it was drivable. But the problem was the motorhome went on fire when it was plugged in. So
landline.
the landline was the problem. It never was fixed. The camper never has been plugged into landline. We don't know if it's going to go on fire again.
Right.
So we said we needed
Yeah, but why did you take it away, and then how did it break down?
All right, they wanted it out of there, understandably so. We went,
I'd
we
have been
saw
charging you
Tom.
storage fees a long time ago. That's what gets a person out of there.
We saw Tom,
We're still working on it.
and Tom said it's drivable. It broke down a mile and a half on Brooklyn Stanhope Road. So we called Tom, who is Miss Andrews' partner, and most of the correspondence we did, especially with this most recent complaint, was with Tom, not Miss Andrews, okay? I want that made clear. And we called Tom in the presence of an officer and the tow truck man. I said, we don't know what to do with this. Can we bring it back? Can you, and I said, well, we will pay
And what did Tom
storage
say?
fees. Tom said, fine, $60.
Why isn't Tom here?
Hey, somebody has to run the company. We're very small.
Okay, but if Tom's the one doing all the dealings with them, why don't you stay behind? Or you think
Because
Tom's
I
a
do the
pushover?
dealings. They're saying one thing, but that's not necessarily the truth.
Right, but if they're
lie.
saying that Tom is the one giving the permission and Tom this, and we only talk
Tom
to Tom.
wasn't there to give permission. He had left. He didn't know that it was coming
Okay,
back
so
to
was
us.
Tom surprised when he got there too?
Yes, he has his sworn
All
statement.
right, in any event, the thing is there, and then what happens? You tell them, get it out of here?
Correct. We were going to allow them to store it from November to February and get it out of there.
So who agrees on a storage
The Obermillers and I agreed.
What? Never spoke
Absolutely
to her
not.
about
We
this.
did it with Tom in the presence of an officer and the tow truck
No.
man.
We're not talking now about you bringing it back. We're talking now about how much you're going to...
That's when we
Exactly.
discussed the storage fees.
Is there a
because I-
written storage contract?
No, there is not.
We were all standing there.
And, yeah, but that doesn't help me now, right? Because there's a dispute about what was agreed upon.
She wasn't there.
Donna wasn't there at all.
We were.
And no one was there. When we got back, there was no one there. It was all done through a phone call.
How much were you supposed to pay in storage?
$60 a month.
How much do you say they were?
$120 a month.
Okay. How are either of you going to prove your positions?
From credibility,
I chose
Judge.
120 because of what everybody else charged around the area. I was going
Everything's
$4 a
lies.
day. is
Can you
what-
stop talking? Thank you. Go ahead.
$4 a day is what everybody gets for storage around in our
Okay,
area.
but I'm not asking you to prove it's reasonable. I'm asking you to prove they agreed to it, which is very simple.
Unfortunately, I can't.
You email, you get something in writing so that they're agreeing to what the amount is. You send a certified letter, you do something. Because
sent-
now we have a dispute about the amount of to be paid.
Correct.
Because we know zero was paid for 5 years.
Right. Unfortunately, I didn't.
Okay.
I sent
Do
certified
you have an
letters.
affidavit from Tom about any discussions he may have had with them?
I have a sworn statement from Tom.
Yeah, let me see that.
Thank you.
So now the thing comes back to you on what date?
I don't have the date in November. I apologize.
All right, so the thing comes back sometime in November. What year? Can we narrow it down to a year?
2013.
2013. And then it stays there until when?
Until June of 2014.
All right. And during that time, according to them, they're supposed to pay $60 a month. Did you pay $60 a month? So how much did you pay?
Fred went for 4 months and paid
How much?
$60 cash,
Okay,
okay?
but it's not 4 months,
But we
it's
don't.
7 months.
He paid 4 months cash. We do not have a receipt for that. We do not have a receipt. Then the last 2.5 months, when we said we were taking it, we took it after they were gone. We made sure we text Tom to say we were
What do you
going
mean
to
you
pick
took it
it
after
up.
they were gone?
Well, after hours, because they closed at 5 o'clock. Well, I was at work, so I needed to go with him.
Well, that and you needed to take it before anybody made you pay anything else, because that's the other
absolutely
version of
not.
what you just said.
Absolutely not, because we paid every month.
They were made aware of the fact that I was
I'm
coming
sorry.
after hours.
Can you prove that you paid 7 months worth of the $60?
I have the last 2.5 months, I had written a check with a note saying this is the final amount that we owe you for the agreed upon storage fees, and then Donna sent the check back.
So you've paid zero.
Well, she didn't take the money.
So, but the bottom line is that at the end of the day, you've had your RV stored for 6 years almost, and have
With it
paid
not
zero.
working at all, because it doesn't work.
Okay.
It's sitting in our driveway.
You know if they, I understand what you're saying. It may be time to give up on the RV.
I'm
yes.
ready. I don't even know how to get rid of it. It's like sitting there. I don't know what to do with
Okay,
it.
well, according to you, it's worth $98,000.
Not anymore, it's not.
No, clearly not.
Well, book-wise.
That's what it was. And I mean,
Well, if it runs, maybe.
it's sitting in our driveway and we don't know what to do with it. And there is no problem with us storing, by the way, because we have a very big driveway. We just wanted the thing fixed. We wanted the insides
Okay,
fixed.
can you stop talking a second so I can read
Sure.
what she handed me? According to him, there was no more communication between you after he left you at the school. The following day when he arrived at work, he found it parked where it was had previously been, that Donna called you and asked you why was it in our lot again, and that you said, I have nowhere else to take it, and could you store it there for 3 months? And that Donna's the one who struck the agreement between you and them, and that it was for $120 a month. So when the first month comes and they don't pay it, what do you do?
I have certified letters.
Okay, and let me see your certified letter. Talk to me about how you paid cash for storage fees and didn't get a receipt.
That's the whole idea.
First of all, I need to go back
What's the
and
whole
explain.
idea?
Tom, I need
No,
to
you don't.
explain.
You need to answer my question.
Cash.
Yeah, I know, cash. So what? You pay
records.
cash, but why wouldn't you get a receipt for the cash to prove you paid cash?
No records.
No, he gives you a receipt. He doesn't keep record of it. If that's what you're trying to imply, if he wants it under the table or whatever, that doesn't mean you don't get a receipt. You still get a receipt so that you can prove that you paid him. Otherwise, everybody in your position could claim they paid the whole thing cash.
Yeah, you're right.
Right.
Yeah,
Stupid, I guess.
Your Honor, may I
very good. It's almost like you've watched me all your life. Go ahead.
Previously, we had done work. I have that invoice.
Lies.
They did pay cash, and we kept a log. They would never give me money unless we initialed everything.
We had a contract
So-
with that. That
Well, you
was
have a
the
contract with this.
We had a contract
Wait,
with that.
stop. You have a contract with this. It's the same thing. It's
So
a
I don't
verbal
know if she wants
contract
to
with
see
this.
Okay.
And it was with Tom for $60.
I don't care what you say. I care
All
what
right.
you prove. The fact that you say it louder and say it while I'm talking
Okay.
doesn't help you.
All right, but after
Stop
we got the
talking.
letter, you're not listening.
Stop talking.
You're not listening.
No, I'm not.
Welcome back to the People's Court, RV11 here. So, do the defendants have to pay something, the $120 thing?
Yeah, I think they should definitely pay something if they agreed on a loose amount at the
The
beginning.
loose amount is no amount. They just said we'll pay something, presumably. If that's the case, do the defendants have to pay anything?
I think if there is no specific agreement, there should be no specific amount that they have to pay.
Okay, who's going to be the tiebreaker here? How about you? Do the defendants have to pay anything?
I think they should.
$120 a month?
Maybe that's a little much, but I think they should pay.
Okay, going inside the courtroom.
Now, these are the certified letters that you sent. Were these picked up or were they returned for not picking up? They were received.
They were received.
They're received and signed for. Okay, the first letter comes in May of 2014. It says two interesting things to me. The letter's from you, and it says, according to your conversation with Tom, this vehicle was only scheduled to be here for 3 months. It is now 6 months. But it also says you owe us $120 a month, and that's in May. Do they answer that letter?
No.
Okay. So now June comes. That's interesting. This is fascinating. Are you Lynn?
I'm Lynn.
Okay, here's a note you write, Tom. When we went to pick up the motorhome, Donna was already gone. This is on June 22nd. We left for camping on Monday, and we will be gone until after July 4th. I had cash for you for April, May, and half of June. But since we won't be home, I didn't want you to think I wasn't going to pay you. So you didn't pay April, May, or June.
Right.
So here's the check. You know what I'm astonished about? When you say, oh, storage isn't a problem, you didn't keep it there 3 more months. You kept it there 6 more months. Storage must be an inconvenience of some sort, or it would have been moved. You agreed to pay for storage, which means that you're cooking up another plan of what to do with it. You're not ditching it.
No, we're waiting for the parts.
I'm not asking a question. So you're sitting there now with free storage for almost 6 full years, and all they are asking for is $120 a month in storage, and you're still arguing about it. When you two don't have proof of what the agreement is, other than your flapping gums, what happens is the judge decides what an appropriate amount for storage is, okay? And I decide 120 is appropriate. So I am ordering you to pay the $800, especially under these facts. I am ordering you to pay the $890 plus prejudgment statutory interest that is applicable in your state.
Thank you.
That is my verdict. Good luck, folks.
Thank you, Your Honor.
And we still have a motorhome that doesn't work.
Yeah. Here's the defendant here. How'd that go?
Not well.
No.
Because the truth was not allowed to be said.
It was allowed to be said.
Not the truth that as it happened, because
Someone hear it?
her partner was Tom, and we dealt with Tom with everything, not Donna. So no, the truth was not heard.
It's all fantasy.
Why don't you get a receipt when you're paying cash? Get a
That was
receipt.
foolish. It was
Yeah.
foolish. It was.
Evidence, you have evidence of paying, and it backs up your story.
Yes. Well, it's a lesson learned.
What are you going to do with the motorhome now?
Oh, I guess I'll have to get the parts and have it fixed or fix it myself.
Yeah, that'd be nice. You can travel around in it.
No, I had to go out and buy another one.
Oh, okay. All right.
All right, guys.
Good.
You would right this way?
Okay. All right, so come on in here. What's your reaction? This case finished?
I'm glad.
What
It's
are you
over
gl-
with.
You're glad about what?
Being done with them.
With them? A little too easygoing, are you?
Just trying to be understanding and treat people how you want to be treated, that's all. So.
Wow, you lucked out, huh? Harvey?
So in this case, judges will do this where there's clearly an agreement to pay something. Judges oftentimes will come up with a reasonable amount. That will do it for this case. Litigants for the next case on the way into the courtroom right now.
This is the plaintiff, Steve. He says he rented an apartment from the defendant, and as it turned out, the place had a rat problem. The defendant didn't do anything about it, just brushed it off, and he wasn't about to live with the constant sounds of them running wild in the apartment and behind the walls, so he moved out. The defendant refuses to return his unpaid rent, plus the cost of the dress suit a rat ate. So he's suing for the $777.41 he's owed. This is the defendant, Scott. He says the plaintiff's making the whole rat infestation problem up because he couldn't afford the rent and moved out with no notice. The plaintiff's being ridiculous, thinking he'll refund his rent when the plaintiff was the one who ran out on him. He has other tenants in the building, and he would have heard about rats from them for sure if there were any. He's accused of being a rat-tattooey landlord.
All parties, please raise your right hand.
Welcome back to the People's Court. Next case in the docket, the plaintiff says the apartment he rented from the defendant had a rat problem, so he bailed. But the defendant says the rat thing is a total lie. It's the case of you, dirty rat.
Thank you, Douglas.
You're
Okay,
welcome.
Steve, you are suing Scott for $777.41 that you want returned to you in rent and the cost to replace a damaged suit because according to you, he rented you a place that was uninhabitable from rat infestation.
Correct.
What happened?
Basically, I left in a hurry on January 12th because several incidents had occurred.
How long had you lived there?
I lived there since June 1st, so it was about 6 months.
Okay, and what had occurred?
I had known about the rats, and on November 22nd,
You had known about the rats since when?
Well, tenants had told me about it, but I was in a little bit of denial. But I saw one in November, and I texted
Did you know about it before you rented the place?
No, of course
okay.
not. And once I was there, I texted him in November that there were rats, and he brushed it off. And
Okay, you texted him in November, and how did he brush it off? He just didn't answer your text?
I told him about it, and he played it off. He said, was it a rat? Was it a mouse? I said, I lived in New York City for 10 years. I think I know the difference.
Okay. Okay, and did he send an exterminator?
Of course not.
Okay, and did anybody else complain about rats?
Yes, they did.
All right, and how do you know that?
All the tenants, we talked about it all the time. There were
Are
two
any of
women.
the other tenants here to testify?
They are not.
Do you have any affidavits from any of the other tenants?
I do not.
Okay, so what happens?
So what happened is on January 3rd, I was in the city all day, and I came home and I went up to my room, and I found that my headphones had been chewed on. I left them on the floor. See, I didn't eat in my room. I didn't even eat in the kitchen, so I never expected to see rats in my room. And I saw that they chewed on my headphones.
Will you hand that to my bailiff, please?
So then I texted him about this, and I told him it was unacceptable, and...
Do you have those texts?
Yes, I do.
Okay.
Yes, you'll need gloves for this.
Yeah, I don't
Where are
want
my
rat
gloves?
juju. Okay.
So that's what I found. There was the inside, the foam was all over and I was dumbfounded. I didn't know what it was. Then I realized, oh, they got in my room. This is bad.
Mm-hmm.
Then in January 4th, I heard one in the TV room. That was the first time I ever heard one in the TV room. So this is a Winston Smith moment coming here. And on the 5th, I left these lyrics. This is a lyric sheet. I left this down in the piano room, and it's this triangular bite pattern. Why they would bite this, I have no idea. But I contend that bite is consistent with all the other bite patterns that you'll see for all the other things that were destroyed. On January 5th...
Because they're sharpening their teeth.
Yeah, I don't know what they're doing, but they would chew at one of the doors in the kitchen, as well, so there'd be all this sawdust on the floor in the morning. It was pretty bad. So I had the lyric bite on January 5th. I saw one in the piano room, and I texted him. I said, they're walking around the piano room as if they own the place.
You didn't happen to get a picture, did you?
No.
Okay, go on.
It was dark.
Yeah.
And then I heard them, the other tenants had said, yeah, you hear them in the walls and the ceilings all the time. I had never done that. I had never heard them until the night of January 5th when I heard them in the walls, and it was a pretty terrifying night, as you could well imagine. So I informed him by text on January 6th, you can start to advertise my room, and then on January 7th, I said, I'm out this weekend. And then I saw him January 11th, which was a Sunday, and I had no idea you were leaving. This is, I'll give you back.
Have you ever communicated with him by text before?
All the time.
Okay.
Yeah.
Let me see your text on your phone. Tell me what's going on, sir.
Where do you begin? I've owned this home for 10 years. I have tenants that have been there for 6 years. They're happy there. The month before he moved out, he had asked if he could use half his security deposit as the rent for the month and give me half a month's rent. That kind of made me start thinking that maybe he's having some financial difficulties. I allowed him to do that. The next month he paid the rent, and then he let me know, I guess the week that he was moving out, that he was moving out. When he moved out, I gave him the other half of his security deposit back. He wanted the prorated month's rent back again, which on a month to month, you don't get your month's rent back. I've been a landlord for 20 years. So I told him I'll give him the rest of his security back, but I'm not going to give him the rest of the month's rent back because I need to try to now, in a last minute, try to re-rent the room.
Right, but see, the exception to what you are saying is if you are not doing your landlord duties. Then, if you are not doing your landlord duties.
Right.
For example, if there's a rat infestation that he can prove and it's not a ruse, and you are just ignoring it for a month and a half, he has a right to leave and get back any penny that he is unused, because if the place is uninhabitable, then you don't get to keep any of that rent. So that is really my question. Did you ever receive complaints from any of the other tenants about rats?
No, I never.
You have never had another tenant complain about rats?
No. I also have found out by calling up a couple companies that I guess mice and rats are delicacy eaters, which means they like food and good food. So why would they be upstairs in his bedroom eating an earphone unless they were looking for his earwax? I'm trying to understand what they want with his earphone.
Okay. It's A, it's not that funny, and B, they eat anything. They eat anything, including in an effort to sharpen their teeth. They eat anything when they're looking for nutrients. So I really need you to tell me what, if anything, as a landlord, you did when you received a text from him on November 22nd saying, I saw a rat in the house, not a mouse, very disturbing. Ernie says he can get rid of them. Who's Ernie?
Another tenant.
I don't understand how neither of you have anything from the other tenants.
Some of them are still living there, so they might not have wanted to.
Go ahead. The ones that
I
work.
also took some photos, so you don't think that this is a
No, the nicest places. The nicest kids could get head lice, and the nicest places can get rats. It's just an issue of eradicating the issue. So now, tell me what efforts you did after you received this from him. I don't see a response from you on November 22nd.
Okay, I contacted a couple of different companies just to make precautions.
I don't know what that means. Did you hire somebody?
Yes.
When did you hire somebody?
Probably right around the January time. They came and they put on the outside of my house these plastic boxes where I guess the rodents are supposed to go inside and eat food, and they put like 4 of them in the 4 different areas. They called them quadrants of my house, just to an argument, just to try and see in case there's anything to lure them outside. I also went into the Home Depot and bought the mouse traps and the rat traps and tried to put peanut butter and stuff, and they just sat there and nothing was there. So
Okay, are you telling me that you hired a company and that the company attempted eradication and that they did not find a single rat?
That is correct.
I need proof of what you just said.
Okay.
You should have a report from that company saying what you just said.
Okay, I do not.
How could you not? That's the entire case is this, to show that he's making up the rat problem.
But in the 10 years I've been...
I don't care about your 10 years any more than you care about my 20-something on the bench. I want proof.
Right.
You picking up what I'm putting down here?
Right.
Okay, so if I give you a recess, will you be able to get proof that says that we went in there and there were no rats?
I can try. I could call up the company and see.
Good.
And his proof is where?
Pardon me?
His proof is where? Where is his proof?
Oh, you didn't see it?
He doesn't
Take
have
all
photos.
the rat bitten up stuff and put it on his desk, okay? And then you
But how do
go
we
call
prove-
the
how do we prove
company
that that's rat?
and find out. Should I waste both of our times, or are you not going to get this?
I'm just wondering how we prove that that's
I want to
rat.
know if I should waste both of our time or whether you think that you're not going to get this. What do you think?
All I could do is call the company.
Great. Court's in recess.
All rise.
So how many rats does it take in an apartment for a tenant to have the right to bail?
One.
Just one rat?
Just one rat.
Yeah, but that can happen, right?
One rat, that's it, man.
And you can leave and not pay anything? One rat?
No, I think it depends on how it's being handled. If this rat is being, exterminated and everything is good after that, you're good.
What if a second rat shows up?
Well, then maybe that's not the good.
Yeah, second rat's a bad sign. Going inside the courtroom.
Okay, Scott, were you able to get the proof that there was no rat problem from your exterminator?
No, Your Honor, I was not.
Okay. All right. There's a surprise. Now, you are claiming $200 for a damaged suit. Let me see the suit that you're talking about.
Yes. It's right down there. She'll figure it out. She's good like that.
Oh, my. Okay, then. Do you have a receipt for this?
No, I bought that a long time ago. That's the suit I got married in, and I still fit into it.
Are you still married?
No.
Then it doesn't have a lot of sentimental value.
It did make it longer than the marriage, I guess, huh?
Yeah, it's actually in very good shape. Okay, I am ordering the defendant to return the $577.41 because I find that the plaintiff has been able to prove that the apartment was uninhabitable in its condition. I am also ordering the defendant to pay the plaintiff an additional $75 for the depreciated value of the suit. That is a total judgment in favor of the plaintiff in the amount of $652.41. That is my verdict.
Both sides, hold on, please.
Well, the plaintiff proves his case, and so you, as the landlord, if there were rats in there, that's disgusting, right?
Absolutely.
Right. And so, what are you going to do about it?
There are no rodents inside my home.
Who ate his headphones? You?
Yeah.
What do you think happened?
I have no idea.
He just chewed on him and brought him in here to win the case, probably. Good move. It's one way to win a case. All right, head right down this way. Why did you eat your headphones in your suit? Why'd you do that? Just to win?
I'm a vegetarian.
Uh-huh.
Just kidding.
I mean, how disgusting is that when you see it?
It was definitely disturbing. There were several that I saw, but...
Rats in your house?
Yeah, that was bad.
How big were they? Okay.
Garden variety size, but...
Garden variety size rats?
Yeah.
All right, so you moved out?
Indeed.
Mm-hmm. And now?
Nothing.
No
Maybe
rats?
some ants.
You lonely?
No.
Harvey?
Okay, in every state there's something called a warranty of habitability. It's implied in every lease, which means that you have a right to reasonable health and safety. If you have a rat infestation problem, that's a huge breach of that warranty. And that will do it for this case. Litigants for the next case on the way into the courtroom right now.
This is the plaintiff, Frances Chambers. She says she brought her car to the defendant's car wash, and when one of his workers pulled it out of the wash, he rammed it right into another car. Her airbags deployed. She called the cops, and the louse still refuses to pay for her damages. She will not let the defendant just wash his hands over all of this, and that's why she's suing for the $4,918.16 it's going to cost her to fix her car. This is the defendant, Dennis Singh. He says he admits his employee tapped the front of the plaintiff's car, which caused one airbag to deploy. But the woman's trying to extort money from him. That's right, he's willing to get her car fixed perfectly, but the woman's trying to scam him into paying almost $5,000 for a 22-year-old car with 127,000 miles on it. And he won't be scammed because the car isn't even worth $5,000. He's accused of being wishy-washy.
All parties, please raise your right hands.
Welcome back to the People's Court. Next case in the docket, the plaintiff says the defendant's car wash employee plowed her car into another car, and it was so bad the airbags deployed. But the defendant says, yeah, but it was just a tap. It's the case of, hey, you're nothing but hot airbags.
Thank you, Douglas. Francis Chambers, you are suing First Street Car Wash and Quick Lube Incorporated, represented here by Dennis Singh. You are the one of the owners?
Yes.
All right. For $4,918.16, the amount that you say it's going to cost to fix your 1993 Volvo. Okay. What happened?
On the 4th, April the 4th, I went to have the car washed there, which I have gone many times to have it washed, and it's always been done very well. This particular time, after putting it on the belts and after completion of the car wash, the worker brings it out from the car wash, and usually it's brought out right in front, continues in straight. Now, this particular worker I have never seen there before, and I've been there over a dozen times. When he brought my car out, he turned and made a right turn, and he went there down, and he hit a parked vehicle, and my airbag deployed.
Oh my goodness. Okay.
And it was smoking, and like it was catching on fire and all that. So then
like it was catching fire, or it caught fire?
It was smoking. Smoking like that. So we asked who was the manager. The manager said his name was Ryan.
Ryan, that's you? Come on up.
That's you.
Were you there that day?
Yes.
That must have been a sight to behold. What'd your guy say happened?
When he pulled it out of the washer, as he was coming out, he stepped on the brakes, and the brakes wasn't holding. So from running into the street.
Where's he, so I can cross-examine him?
Oh, he's not here.
Why isn't he here?
He's off today.
Oh, he's off today. We wouldn't want to inconvenience him with actual testimony. See, if he's off today, that's all the more reason to be here, because usually the excuse I get is they're working and they can't take off work. But you're his boss, so you could have him come here. So the only reason I could see to not bring him here is that he refused to perjure himself, and that you thought it would go better for you if he didn't come. Because I'm finding it hard to believe that there's a brake problem, and the magical moment when he crashes a car, did you see a brake problem? Did you feel a brake problem? Did you sense a brake problem?
No.
You have had this car since when? Were you the original owner?
I'm the original owner of this car. That's the first time that the airbag has deployed, and the car was.
So you've owned the car for 22 years?
Yes.
You must have taken care of this car like you read about.
I plan to have
Your car is as old as my marriage, and my marriage is old.
That's a well-kept car.
I'm sure it was. It's hard to get something to last 22 years. Yeah. Including marriage, but it's hard to get a car to last 22 years.
It's never had that airbag. It's never been deployed.
Is a car fixable? But just to the tune of like a heck of a lot more than the car's worth.
Well, what happened is Brian came out and he looked at it and he admitted that it was their fault and it was quite a bit of damage there, done. And he said, let me check with my boss.
Did anybody ever say, oh, the brakes, did anybody say the comment that the brakes failed?
No.
Nobody?
No.
Not until they get sued, did they say that?
No. All right. No, the brakes. And the car had been inspected anyway in December. And I had no problem. My husband was very, very ill, and he was up at the cardiac rehabilitation unit there.
How's he doing?
Very badly. We don't think he
I'm
might
sorry,
not,
darling. I'm very sorry.
He might not make it. But anyway, I had a hard time, going backwards and forth. He's at the cardiac rehabilitation unit there at Cortland Manor. So that's where I was going back and forth. It takes an hour to go.
So what have you done? Is the car drivable right now, or it's not?
Oh, yes. I was going to get to that.
So you're able to drive it.
So do you believe that the brakes failed and that's why the car wash employee crashed the car?
No.
Because?
Because that would be not really,
Well, how about this? Let's get broader than that. Do brakes fail on cars?
No, I mean, I guess it's an old car, but it's kind of hard to just fail.
Just happens to be at the car wash that the brakes fail. Going inside the courtroom.
Let me see pictures of the damage to the vehicle. You can get up and help. No worries.
Let me help her out.
Sure.
What we want to show is that we have a video that where it happened at on because she called me after.
There's a dispute about where or how it happened.
And then what happened was he admitted that it was damage, and he also wrote on a receipt that they agreed to pay for what was.
Let me see that.
What was?
And let me go ahead and play the video and let me see that.
Now, the airbag deployed out. Some of it looks like. And here's the seat belt. It doesn't go over. It's stuck too. That's part of it. Okay, this happened here.
Okay, let me see your all the paperwork that you have that you wanted me to see where he scribbled we're responsible, and let me see also the estimate for the repairs. You do also have to understand that no matter how valuable the Volvo was to you, there is a market value for the Volvo beyond which you cannot, I mean, you can't, in other words, if a car's worth $1,000, you can't ask for $20,000 to fix it because you really, really loved it. You understand what I'm saying? You are capped at the value of the car. Not the value of the car to you because it's sentimental, but the value of the car.
I understand that, but we're in a unique situation. My father is pretty much dying.
I am very sorry about that.
Another
And
car.
I am not only sorry about that, I'm very sensitive to that because my father died a few months ago. However, that does not change a legal verdict.
We don't have the money. She doesn't have the.
I understand
loaned her
that
the money
too.
to even make the down payment.
And I understand that too.
Okay.
And there's going to be a money judgment recovery here, but it is not going to be $5,000. It's going to be the value of that Volvo. That's what everybody gets, regardless of the difficult times that they're going through. People's recovery, their legal rights don't become more because of a hard time or more because they're going through financial difficulty. That's not how the law works. Could you imagine such a scenario? All right. Tell me, Ryan, when you say the brakes were faulty, why isn't that in here in the little memo that you write to her?
Because she didn't want it on there when the officer was there.
Really?
I wrote
Really?
it. I wrote it and I had to take it off.
Really?
Yep.
I don't think that's truthful. I really don't.
Would you mind asking her if she told me to take it off?
Oh, yeah, well,
put it on there?
That's a good idea. Did he write the brakes failed in the first paper?
Not right.
No, that didn't go so well.
That was not there.
But the fact that he says, would you mind asking her, is kind of bold if it wasn't said. I'm done. I am going to order the defendant to pay the plaintiff the Blue Book value of the car, which is $1,500. That is the most that I can legally award you, and I'm giving you the most that you can legally be awarded. Good luck to you. $1,500 verdict for the plaintiff.
Both sides. So the plaintiff maxes out on the Kelly Blue Book value of the car, and the defendant right here, what's your reaction to this outcome? You lost badly here.
I honestly feel that was fair because we did offer her the value of her car, but she didn't accept it. She wanted the full amount to repair it, which, as the judge said, she wasn't legally entitled to.
Well, why didn't you bring the guy?
He didn't want to come.
He didn't want to come. Don't you think that would have been important to your case, though?
I did think it was important.
Or you don't think he would have helped you one bit?
He wouldn't have helped us one because we never denied the allegation. We agreed that it did happen at our location. I did agree to fix it, but she just wanted too much money.
You think water got on the brakes, or what happened?
I do feel that water got on the brakes, and being such an old car, it may have not stopped, but it did hit the other car, but the damages weren't that significant.
All right, okay. All right, around the corner this way, okay? Thank you, and all right, come on out here, and you understand how the judge was bound by the value of the car. Could you step up just a little bit here and join us for your reaction to this case?
Yeah. Well, we think it was not fair. I mean, we realize that that is $1,500 is the book value, but if I have an old car and you just go in and total it, what am I left with?
Right.
And they're the one that's really caused the damage.
Well, that's all understood. That's all understood,
But I mean, I guess it would help towards what, she still owes the guy. still a mechanic.
Right. You're gonna keep that 22-year-old car going.
Afford anything
keep it
else.
going?
Can't afford anything else.
How's it running?
Excellent. Excellent.
Great.
Very good.
All right. Well, good luck with the thing. Keep it going. Watch those brakes.
I think
Nothing wrong with the brakes.
There's nothing wrong with those brakes at all.
Okay.
Just had it inspected in December.
Harvey?
You know, Kurt, it sounds really unfair, but when you have a car and it's a used car and it's an old car, all you get is the Blue Book value, and you're probably going to have to pay a lot more money to replace it, but that is simply the way the law works.